Benchmark has recognized our next speaker, trial lawyer James Sullivan, as Canada's leading class action lawyer, and his firm, Blake, Castles and Graydon, as Canada's leading class action law firm. Jim will talk today about improving settlement prospects and class actions. Together with the network's chair, Scott O'Connell of Nixon Peabody, Jim will compare Canada and U.S. approaches to judicial approval of class action settlements. Please welcome Jim Sullivan.
Thank you very much. I am very pleased to be joined by my good friend Scott O'Connell, the co-chair of Nixon Peabody's litigation department and an expert in class actions and aggregate actions. Today what we're going to do is I'm going to start off by taking a look at the Pella settlements. It's a case that was settled both in Canada and the United States, and talk about what happened with those settlements. And then Scott and I will talk about some of the implications of that with regards to class action settlements in cross-jurisdictional actions. One of the things that commonly occurs is that an American class action will have a companion piece. In fact, we often call it the dog and the tail. The United States action is the dog, Canada is the tail that we follow on to American class actions, and that what happens in the American class action is often mirrored in Canada. And the Pella class action is a good example of this. Pella is a window manufacturer. The windows allegedly had a defect which allowed water to enter into them. This caused rot and caused structural damages to homes, leading to loss. One of the allegations in the case was that Pella was aware of this manufacturing defect and drafted their warranties in such a way as to protect them from these types of claims. Settled in both countries. Settlement was approved in both countries in first instance. It went on appeal to Judge Posner in the United States. Judge Posner took offense to the settlement, and I've put there some of the headlines that are present in the various newspaper articles concerning Posner's decision. Pella class action settlement is so bad, court tosses lawyer and his father-in-law lead plaintiff. Posner savages scandalous settlement in the Pella case, and Posner tosses scandalous settlement, says judge didn't heed danger signs. What happened in Canada? Settlement was approved. So the question arises, why? Why was a settlement ultimately overturned in the United States, and why was it approved in Canada? And to start off, I think it's instructive to take a look at the various settlement procedures in both countries because they're very similar. Once a matter is certified in Canada, it can only be settled through the approval of a court process. The settlement terms have to be set out in an affidavit to the court explaining what the terms of the settlement are, the reasons for the settlement, the fees to class counsel, the explanation as to those fees to class counsel. There has to be notice to the class prior to the hearing, allowing any class member that wants to attend and object. Objectors occurred actually in both Canada and the United States with regards to the settlement process. And in Canada, settlements are typically approved by the court. And the actual settlements themselves were very, very similar. In both countries, there was compensation, a small amount, to the named plaintiffs. There was a maximum damage award per structure or per house. There was a maximum damage award per windows and installation. Coupons were part of the settlements. Warranties were extended where applicable, and counsel fees were paid before the process was complete. So very significant elements of the settlement were precisely the same. It's also a lengthy and complex form of notice that was given. This was the exact same form in both countries. There were lengthy claim forms. Significant information was required to complete those. The claim form could be rejected and the claim rejected if it was not filled out completely and correctly. And any reduction in legal fees or any reversion in the legal fees went back to Pella rather than the class. Now, there were some significant differences. One of the differences was that in the United States, plaintiffs' counsel estimated that the settlement was worth $90 million. That was based upon every potential class member making every potential claim. The defendant's estimate was between $8.5 and $22 million. Justice Posner found that the more realistic number was the 8.5 number when coming to the settlement. In Canada, there was no estimate given of the settlement, and that's not unusual in our settlement process, that there is no estimate of the actual value of the claim given. Another difference was a difference in class counsel fees. In the United States, class counsel fees were $11 million. In Canada, they were $650,000. Now, when you take the 10-to-1 ratio in our populations, that takes Canadian counsel fees up to the equivalent of $6.5 million, still only about half of what the American class counsel were getting. Now, importantly, in both settlements, was this different in the class counsel fees? There was no real explanation for the $11 million that class counsel was obtaining in the U.S. case, other than the fact that the claim was worth $90 million. Judge Posner took issue with that, given that he thought the claim at best was worth $8.5 million and the legal fees were $11 million. In the Canadian claim, the affidavit supported set out the number of hours the firm had worked, the amount of fees that they had expended into the case, and that there was a 2.2 multiplier on those fees, so they were getting approximately double what their legal fees were, but then they put in the fact that there was risk that it was on a contingency fee basis, that if they had lost, they were going to get no money, and so that was looked upon favorably by the court in Canada. The other big difference was that in the United States, there was a real question of the independence of the representative plaintiff, given that it was counsel's father-in-law. In Canada, the representative plaintiff was independent of counsel. This led to objectors in both countries, as I said, but the objector in Canada was objecting to the quantum of any individual amount rather than the process and settlement itself, and the court said that really wasn't an objection to the settlement because the class member could opt out of the settlement and ultimately bring their own claim if they were unsatisfied with the resolution that the class was obtaining. In the United States, the objectors were quite different. The objectors in the United States were made up of 4 of the initial 5 representative plaintiffs. The 4 representative plaintiffs had been replaced by class counsel as a result of the fact that they were objecting to the settlement, leaving only the father-in-law and new representative plaintiffs that were in approval of the settlement. And Judge Posner took a very dim view of that and said that it was a bright red light warning sign for the class counsel and for the judge that the settlement ought not to be approved. The other issue that came up before Judge Posner that could not have come up before the initial court was, in fact, the take-up rate. And the take-up rate of a class of 225,000 notices being sent was 1,276 people, or 0.057%. Judge Posner said that the remarkably low take-up rate was another concern with regards to the acceptance of this settlement, and in fact led to claims being made of less than $1.5 million. So the question then becomes, what are the implications for settlements in Canada and the United States? Canada has a generally accepted lower bar for certification of class actions. I think that it's fair to say that there's less scrutiny with regards to class action settlements in the United States. We've seen within the United States class action reform coming, and this has led to the possibility of forum shopping between Canada and the United States. Interestingly enough, we see growing relationships between Canadian and American plaintiffs' firms with regards to bringing class actions, and in fact, we have seen in Ontario some American class action lawyers actually moving to Canada and bringing their practices to Canada to bring class actions in Canada. This ultimately means we may see larger claims being brought in Canada as our courts are expanding their jurisdiction with regards to class actions, and claims that may have originally been brought in the United States now being brought in Canada. One of the interesting things that happened this week with regards to class actions was with regards to the American Express settlement, and as you may or may not know, that was not approved by a Brooklyn judge in the U.S. federal court. That was not approved because of allegations of improper communication between the plaintiff's counsel and defense counsel for MasterCard in a different class action, which were under the reline on the emails, burn this email, which I think shows a rather cute naivety as to the existence and permanence of email. But it does go to the fact that I think there is a growing scrutiny with regards to settlements in the United States, and I'd like to finish this part of the talk on a quote from Judge Posner in the Pella case, where he says, "Class actions are the brainchild of lawyers who specialize in prosecuting such actions and in picking class representatives. They have no incentive to select persons that are capable and desirous of monitoring lawyers' conduct in litigation. Class counsel, ungoverned as a practical matter by either the named plaintiffs or the other members of the class, have an opportunity to maximize their attorney's fees at the expense of the class." Sadly, in Canada, I think our judiciary is still enjoying the relatively novel class action procedure that is available and has not gotten to the rather jaded and realistic, in my view, viewpoint of Judge Posner. And all I can say is that every time I read the decision, I think to myself, God, I wish Judge Posner was in Canada. Now, what I would like to do is invite Scott up here. And Scott, if you could give us some of your thoughts with regards to this and the application in Canada and United States settlements.
Thank you, Jim. It is actually a fascinating comparison, and it tells every American lawyer in the audience how far we have come with judicial reform, class action reform. It was not long ago that the class action device was being abused horribly by plaintiffs' lawyers in the ways that are evident in the Pella decision in Canada. Conflicts of interest were rampant, and the ability to get low-value returns for plaintiffs with high returns for plaintiffs' lawyers were common. And then 10 years ago, our Congress took action recognizing the abuse and that this was a gambit for plaintiffs' lawyers and a horrible way for companies in America to manage risk with that high threshold of potential financial and reputational harm, and made a change and brought to an end, in many respects, the judicial hellholes where a lot of these abuses were occurring, gave classes a direct path from removal into federal court, and over the past 6 to 7 years, mandates from our very active Supreme Court as to what judges need to do with regard to safeguarding abuses of this device. And let's talk about some of those abuses. I mean, there's a moment in every class action settlement, and it's evident in the story that you've told between the tale of two cities, Canada and the United States, when the adversarial process breaks down and plaintiffs and defendants want a settlement. They want to bring it forward, they want to be done. Plaintiffs are looking for their recovery, plaintiffs' lawyers, to be cynical, are looking for their specific payday, and the manufacturer or service provider or product developer wants to liquidate the claim. And so there's unanimity of purpose, and they bring it forward. But that's where the abuse would start to manifest itself. The adversarial process broke down, and judges were simply asked to rubber stamp deals without the level of scrutiny that happens now. Enter our Supreme Court over the past 6 years, and they say, no, judges, you have a material role here. You have to look at the fairness with particular standards and whether or not the class is benefiting in ways that is improper. And so now the new tension in the system is the judge is your adversary. So there's that magic moment when you want to settle things, but now you've got a new master to serve with regard to fairness, and that's the judge. And the difference that I would say that between our two systems is now our judges have been called upon to fulfill that function, and you will get there. We have been on your road. It's not pretty, but you will get there. And that has had meaningful and salutary benefits for class settlements. And the truth is, it raises some very interesting practice pointers for people who are trying to settle class actions. If it's too good to be true, it may be too good to be true. And sometimes when you're settling a class, it may be necessary to bring in outside third-party experts or consultants to look at the deal you're getting as a corporate defendant to determine whether it will pass muster. Now, Pella was kind of egregious, right? There are all kinds of markers out there that should have put people on warning that this had problem. There's a lot of hair on this dog. All of the objectors had been former lead plaintiffs. The lead plaintiffs quit that role because they were unhappy with plaintiffs' counsel and the way they're conducting this litigation. That is a monumental red flag that there's a problem here with the process. So that may be the exceptional circumstance, although, as you said, on Tuesday in Brooklyn, a settlement gets tossed because the lead plaintiff lawyer, who's now been disqualified from the case, is colluding and sharing confidential information with another card provider, the MasterCard side of this dispute. So conduct of the individuals, the actions of lead counsel, the allegations and recoveries are now going to be under the fine microscope of a judge in federal court for the most part, and that's where you're going to have to get a determination of fairness. And that, if we have the Judge Posners of the world looking at this closely, will suggest that settlements will be rigorously looked at, and all of us in the room have to make sure that we're bringing forward something that will pass muster.
Those are excellent points, Scott, and really, when I look at the Pella case, I think about how would this affect one of my clients in the real world. Here's litigation that's gone on for 6 years. The parties have invested huge amounts of resources into it. The settlement, from the defendant's viewpoint, was presumably a settlement that they could live with. After 6 years of litigation, plaintiff's counsel is now replaced by new counsel. The case does not go back to square one, perhaps, but it maybe goes back to square 2 or 2.5. And the company now has to put all of the resources back into defending the case, into generating a new settlement or going on to a common issues trial. And the key, I think, to defense counsel, as you were saying, Scott, is trying to figure out how do we ensure that our client doesn't get into that situation? How do we ensure that the settlement that we have reached for our client is one that will likely be approved with regards to by a court? And I think Pella and the Amex case are interesting because there really was no reason for the American Express counsel to know about the secret communication between plaintiff's counsel and MasterCard. But in the Pella case, as Scott so eloquently put it, there was a lot of hair on the dog, and all of that hair was known to defense counsel. And defense counsel ought to have considered ways of potentially defending the client and ensuring that the settlement was accepted. Scott?
Well, I think that's right. So practice pointers are, let's look at those things that would raise the specter of collusion, difficulty, lack of an outcome of an adversarial process, and make sure that when you bring the settlement forward, you've got answers for a federal judge that's going to look at this closely and say, in the end, am I willing to do this, not because it's expedient for the plaintiff's lawyers to get their payday and this corporate defendant, but it's in the interest of the class. And sometimes that means, in our situation, largely as defense counsel, we have to go back to the client and say, this deal may not be good enough, which is not a happy conversation to have, but the alternative is to run the gauntlet that you just described, Jim, get this thing overturned on appeal, which was the case in the Seventh Circuit with Judge Posner and Pella, and you're back in the soup all over again. Sounds like high-risk poker. So a little prudence, a little time, a little independent advice before you bring this thing forward with those who can look at those salacious allegations in the case may save you considerable expense and a do-over later on.
Thank you, Scott. Thank you very much.
Thank you.